Someone make it make sense.
Probably a couple.
Hello, everybody. I just realized I was on mute. Woo! Where's Mom? I need Nightbot. Nightbot, help me out here with this one. Hold on. We need WAP in our lives right now. Here we go. And accompanied by Hashtag squirrel power. So yes, excellent. Well, all you guys missed while I was on mute was me trying to remember if it was Friday or Saturday. Because with summer vacation and a change in everybody's schedules means my days feel really weird because all the lesson schedules change. And I was just standing here talking to myself about if it was Friday or Saturday and remembering it was Friday. So that's what we've got. But I am happy to be here. We have a lot planned. It was supposed to initially just be the recap. And then I have been looking, as promised, since yesterday. Yesterday. Since yesterday for the motion that the Commonwealth filed. As you all know, I have not done any pre-trial anything regarding this case. I've been going off of just what comes in at trial. I can't tell you how happy I am that there's been a court filing since the trial started, because now I can cover it and be okay with that. So I'm just so happy. Like when they I hate hearing Lally talking, obviously, right? Like it's like, hard on the ears, but I'm so happy that there's a court filing. And so I've been looking for it since yesterday, although it feels like a lot longer than that. Like, refreshing my search engine like every, 40 minutes, but I found it. So we are going to cover that. And if that weren't enough, besides the recap, we also have a couple other things coming up, including I did my own little experiment today and put a little video together regarding taillights and also, shall we say, tiny hairs on cars. So we have that coming as well. Let me pull this down. But we will do that as part of the recap situation. And what am I looking for? Oh, you're right here. Okay. Yes. Nightbot. We love you, Nightbot. So, oh my God. Are you guys quoting? You are. Oh, don't tempt me for the song. Oh my God. Y'all with Freddie Mercury. I'm so happy to see you guys. Oh my God. Who doesn't love that song, right? Oh my God. I wish I could it's so crazy. There's certain songs, and that's one of them, where it's like just not the same without having all the harmony parts. And it's just tough with because when you're singing it, just one person, all those voices just stay in your head. You know what I mean? What was it? Oh yeah, when I was singing All the Small Things the other day, yesterday, again, we don't know what day of week it is because schedule's a little crazy right now with summer. Might have been Wednesday. No, yeah, I think it was Wednesday. I actually was saying how funny it was because that's when I realized that I've only ever sang along with that song for a couple decades or whatever. I've only ever sang along with it and sang the harmony part. And I didn't realize that until I was singing it. And I was like, automatically, without even thinking about it, I was like, oh my God, I don't know what I'm supposed to be singing because my voice wants to do the harmony part, but yet I have to do the melody. Y'all, hold on.
Hey, he's got a bird in his mouth.
Speaking of which, one of the things, as promised, I realized I'm going to be able to build up to this, add more. But let me add this into my arsenal of clips here. One of the things I did, because I did things. Oh yes, right. I'll give you a little heads up. I titled it Confusion because you get to name everything. I titled this one Confusion. This is for you, DSN. And also I realized that I'm going to end up probably adding to this because it's just going to be too easy. But as per what happened on the live stream, I guess it was the last recap, maybe. This is from DSN's wonderful suggestion here.
And following your graduation from there, where did you go to school after that?
So after that, I attended University of Virginia for medical school. Is that what you asked me? I'm sorry. I guess for your question with respect to it from a diagnostic perspective, I don't know exactly what you're asking me there.
Also, did you guys notice he even says with respect to? It's happening to everybody. I got y'all a super planner girl here. I got a message from her today. It's fine. You guys, y'all have heard me. I've become Lally essentially. That's where we're at these days with in terms of speaking. But we've heard it from everybody. I remember hearing it from the defense attorneys earlier on before it even spread to the greater public, such as myself, that the languaging was starting to morph into Lollyisms. And today I got a message from Super Planner Girl, like talking, like a voice message. And I don't remember what she was talking about, but I was just dying laughing because she was like, with respect to, and I was like, did you realize you just said that? But like, it's happening to all of us, y'all. And we just heard it from Dr. Justin Rice. He said, with respect to. Let's listen again.
And following your graduation from there, where did you go to school after that?
So after that, I attended University of Virginia for medical school. Is that what you asked me? I'm sorry. I guess for your question with respect to it from a diagnostic perspective, I don't know exactly what you're asking me there.
It's so crazy because it's like a virus. It's like these words that they just get into your vocabulary because of Lolly, and then you can't talk, you can't speak without them. But like we never used them before, you know? It's wild. I have not, DSN. I've been teaching and my lessons were running late and I was trying to get everything ready for the live stream. I don't know what it is, but I'm really excited about it. Everything you do is great and we love you. So I'll definitely check that out later when I'm not live streaming. Although, having said that, if it's something that you want me to put live on the internet, we can do it live streamed, I think, right? Can I do that? Yeah, I can screen share it. I can open up Discord and I could screen share it. And but you know, but that's just me thinking out loud. So yas. Yes. Also, just so you guys know, YouTube's been fucking up too. So like when I am running behind and I reschedule the live streams, I have to do it through StreamYard. And YouTube doesn't always update it. Let me ask you guys something. Have y'all ever noticed with like any channel, like literally any channel, where there's a live stream scheduled and it has the time, but then it's like going live in X amount of hours and the two are not the same? Let me give you an example. It might say live stream scheduled for, 4 o'clock, right? And then let's say that it's like 12 o'clock where you're at, right? So that's like 4 hours. So it's like live stream scheduled for 4 o'clock. And then it's like, and that's the time. But then also in the same like description on YouTube, it's like in the left-hand corner, bottom left-hand corner of the screen, it'll say like going live at 4 o'clock. And then it'll say going live in 2.5 hours or something, right? Have you guys ever seen that where the two things are not the same? And you're like, well, which one is it? Does that mean it's happening at 2:30 or is it happening at 4? Have you guys ever seen that? That happened. I've seen that with my own videos, which is insane, where I'm like, oh, let me just see what it looks like with the thumbnail, for example. I'll click on it. I'm like, wait, what? So I think part of that is like an issue where if you schedule it on StreamYard and then you change the time, it's just like there's an issue on YouTube's end. So that I know it's confusing, but I think that's part of what's going on, where if I change the time, it doesn't always register. So yeah. No need for that DSN. Okay, well, got it. All right. So let's jump into this court document, shall we? All right, guys. I'm excited. This is a big moment. Drum roll. Do I have a thing I can hit like a drum? So stupid. That's me drumming on shit. Okay, we got the drum roll. That happened. So this is my very first court document ever reading from this trial. So that's big. Okay. So we have okay, yes, okay. So we have Norfolk, as they say, that's kind of how they say it. Superior Court. All right, Commonwealth versus Karen Reed. Here we go. Y'all ready? Commonwealth's renewed motion for reciprocal discovery and motion to exclude defendant's expert, Dr. Marie Russell. All right. So your planner girl, by the way, I was just talking about you. And we can follow along using this hand. The hand today. On April 15th, 2024, the day prior to trial, the defendant provided the Commonwealth. This is already weird. I've read a lot of court documents. This is already weird. This is already very weird. The caption, first of all, is very different. Y'all have heard it. We've talked about captions at great length. But having said that, different jurisdictions have their different own set of rules for captions. But this is already weird. It reads like a narrative and not like a motion. You know, usually it's like the moving party states who they are in the first sentence along with what they're doing. And instead, we have on April 15th, 2024, the day prior to trial. It reads like it reads like the start of a book. It's interesting. All right. The defendant provided the Commonwealth with a witness list, which contains the names of civilians, police, defense, investigators, and experts. On April 22nd, 2024, the Commonwealth filed, quote, Commonwealth's renewed motion for reciprocal discovery and renewed request for voir dire of any proposed defense experts. And I guess there's a period there. It's kind of hard to see. During that week of jury impanelment, the defendant was ordered to comply within 1 week with, we were doing Murdoch and everything was scrimp. And I was always like, shout to scrimp. That was like South Carolina rules of criminal procedure. So now we are in the world of Massachusetts rules of criminal procedure. On April 29, 2024, opening statements were made and the trial testimony commenced. This is the weirdest shit I've ever read in my entire fucking life. What is happening? Is Lally trying to write a children's book? This reads like a children's book, like a bedtime story about a fucked up trial. That's what this reads like. Oh my God, the word sporadically. Wait, sorry. What? You guys. Is this what all the court documents are like? So we're going to have to read all of them after the trial. Literally all of them. This is incredible. The defendant sporadically provided reciprocal discovery to the Commonwealth on May 1st, 2024 and May 7th, 2024. Why is there case law without any fucking context? There's a period here after the date. Okay. All these problems. All right, we got case law. See, Commonwealth v. Reynolds, 429 Mass, 388, 397. Okay, so first of all, that means that this is a Massachusetts Supreme Court. That's what this case law is citing. What the fuck is happening? But why? Oh my God. All right. This is written as if it should be a footnote when it says the way that this is structured, where it says C Commonwealth v. Reynolds. Oh my God. Wow. Did he? I have so many questions. So this sentence is okay, but this is weird because this should be a footnote. Just to point out part of why, there's a lot of reasons, but the one that is easy to point out is that it's an incomplete sentence. Like, and if you typically, if you were imagining just like the way normal English would read, you might think that you would imagine potentially this being this thing here. Okay, the defendant sporadically provided reciprocal discovery to the Commonwealth on May 1st, 2024 and May 7th, 2024. And then you might imagine that there was a open parentheses and a lowercase s, and in parentheses, C Commonwealth v. Reynolds, blah, 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 right? And then close parentheses. But this is not a complete sentence where it says C Commonwealth v. Reynolds, and then it has in parentheses this is weird. This would be part of the ruling that they want to cite, which typically you would have to, this is a mess. Usually what you see is you would see the case, you would have the cite to the case law, and then you would have, if they want to quote part of the ruling, it would say something to the effect of, which reads in part, and then it would quote it. But If you want to say, when it starts like this with the word C, it should all be a footnote. Okay, keep reading. So what does it say? A defendant's discovery obligations includes, and shouldn't that be include, not includes? A defendant's discovery obligation, yeah, this is plural. This should be include, not includes. Impeachment evidence. And you know what? That's not quoted from the case law. Here's where the quote from the case law starts. You see the lethal hand. Shout out to Nightbot, by the way, with tiny hands. Hold on. Stop everything. Yeah, this is a disaster. Let me just do this because of tiny hands. Yeah, that's such a good point. DSN says if you did a control F, what if any your computer would explode? Yes, and so would my brain. And so would Nightbot, and we don't want that. Look at him. All right. Love you, Nightbot. So, wow. I don't know what's happening. This, you know, this is so crazy. I always say that you can tell a lot about the court documents, like, or you can tell a lot about a case by the court documents, and like, this is honestly, this really is just so much on like par for the course with the trial. It's such a disaster. I don't even know, you guys. I don't know what's happening. Okay. The defendant's discovery obligations. This should be include, not includes. Impeachment evidence. Why is this the okay, keep reading. Quote, allowing the defendant to withhold such evidence against a witness who is certain to be called to testify would undermine the discovery rules and allow attorneys to return to trial by ambush. The objects do not accord with our discovery process. Well, so here, this is the actual front, like this would be from the case law itself. I do, whoever wrote this, whatever judge wrote this, I do love it because this sentence inherently is saying that theatrics are perfectly fine and do accord with trial, right? Theatrics do not accord with our discovery process. It's like ... however. But yes, that's true. Okay, the defendant has failed to comply with Mass Crimp Rule 14, subsection A, or paragraph A, subsection 6, which requires the defendant to produce all intended expert opinion evidence, including all written reports and opinions that pertain to this case and the identity of anything upon which the expert bases their opinion. Commonwealth v. Paiva. So now this actually at least looks like so far it could be a complete sentence. So far. We'll see. Commonwealth v. Paiva, 71 Mass Appellate Court. So this is from the Massachusetts Court of Appeals. And then we have where to find it from 2008, Master Crimp. And there's the rule again, 14A1 provides for an automatic exchange of discovery regarding intended expert opinion evidence. The Commonwealth again renews its motion for reciprocal discovery. Interestingly enough, it's now a pointer and now not a tiny hand. On April 15th, 2024, the defendant identified Chris Van E. You got what? Wait. Hold on. Let me zoom in and maybe it'll be a hand again. Yep. Okay. Is that another typo from Lally or whoever wrote this? But it reads like Lally in a way. Although we'll see how many what if any's, but like what? Is that a real last name? It looks like somebody teaching their kid and it's like uppercase, lowercase letters. Okay. Chris Van E, PhD, as a potential expert witness. Also, shout out to Chris Van E. And if that's not your real name, don't blame me, blame Lally. As a potential expert witness in biomedical and mechanical engineering. Shout out to science. The defendant proffered that, quote, Mr. Van E will testify regarding his opinions and conclusions regarding the Commonwealth's reconstruction and the EDR. Wait, I'm thinking EDM. I was like, wait, dance music? No, that's EDM. Hold on. Okay, EDR data obtained in connection with this case. He will testify to the chronological data derived from the EDR. You gotta love how Lally doesn't, or they have not told us what EDR is, but yeah, right. From the EDR, including key cycles and triggering events from the time period in question. This entire trial is a triggering event. However, this description fails to comply with Master Crimp, which requires the defendant to disclose. They just keep reciting the same thing over and over again. Which requires the defendant to disclose the opinion rendered, all intended opinion evidence, and any reports prepared by the expert. Also, can we just remember for a second briefly here that the Commonwealth has called one expert so far, which is mind-boggling. And the one expert really, in my opinion, just like all the other lay witnesses, helped the defense. And that was Dog Lady. Shout out to Dog Lady. I hate that I don't know her name, but now I feel like we just know that we're just going to remember her that way. But
You use a solo cup.
I'm sorry, what?
Objection, Your Honor.
Solo cup.
she was great. Honestly, she deserves way better than testifying for them. Okay. The defendant also identified 3 experts from ARCCA, LLC, Daniel Wolf, PhD, Andrew Renstetler, PhD, and Scott Klein, BSME. Is that bullshit medical examiner? Because if so, clearly they meant to be testifying for the Commonwealth. As expert witnesses in accident reconstruction. Yay! You guys, accident reconstruction. That's something I can get behind because you know what? We've seen a lot of that. And you know what else? It's a small world, right? Eventually, we're going to start to know these names. And like, half of me is like, okay, accident reconstruction. We saw so many people in Murdoch. We had Kenny Kinsey, but then the defense hired, they had, what's his face? Michael. Oh my God, why am I blanking on his name? The 2 Gray Boys dude. And then there was also the other dude, Mr. Palmbach, Timothy Palmbach. He was the dude who said the 2 Gray Boys were hiding in the ceiling, essentially, pretty much. But there's people that do that, right? And like, it's a small world. Eventually we will know these names. In fact, I'm surprised I don't recognize them already, although it could be that I recognize their faces if they get to testify. Here, the defense is trying to stop that from coming in. But accident reconstruction. The defendant indicated that each expert will, quote, testify consistent with report in possession of the Commonwealth. So there's what the Commonwealth is saying right now is that the defense says that their testimony will be consistent with what the Commonwealth is saying, right? I mean, logic would say that that's probably not the case or they wouldn't be testifying, right? Pursuant to Massar Crimp, the Commonwealth again moves for the defendant to produce all written reports. So in other words, this is what they're saying is we don't believe you, which I don't believe them either, because also why would anyone want to testify consistent with the Commonwealth? Like that means you're lying. That means something's wrong, right? So the Commonwealth again moves for the defendant to produce all written reports and opinions that pertain to the case and the identity of anything. Does that mean any? Are they supposed to say anyone here? Identity of anything? I don't know. This is such a mess. Wow. Upon which the expert bases his opinion. This sounds like Lally wrote it, honestly. The Commonwealth also moves for the defendant to specify what each of the 3 experts did, what their independent opinion is, and what each expert would testify to. I mean, obviously, that's what your normal, that's what they would normally turn over. Furthermore, voir dire is necessary to determine whether each of these 4 proposed experts are qualified to render an opinion about crash reconstruction, whereas all 4 proposed experts are, look at the redundancy here. Fucking hell. This had to be Lally, right? Because we've never seen anything so redundant. Okay, let me back up. I can't speak for everybody. I've never seen anything so redundant in my life or heard anything so redundant in my life as Lally speaking. And I've certainly never read anything, on par with that until this document here. Proposed experts are biomechanical engineers and not crash reconstructionists. So, okay. So this is something that comes up in trials where, so we heard this in Murdoch a little bit. I believe it was in Murdoch, was it? It comes up regularly where you've got what did they call them? Accident reconstruction. So in other words, the Commonwealth seems to be in agreement. They're able to testify as to accident reconstruction. However, now they're saying specifically crash reconstructionists. This gets down into the languaging and the semantics of it. And again, we've seen this before where it's somebody might have all this experience under their belt, testifying about, I don't know, something pretty specific, right? That could be involved with a crime scene, an accident, whatever. But it hasn't been labeled as such another way, right? So for example, someone who might be an expert in terms of how, I'm just making this up, but someone who might be an expert, say, in how effective brakes work in terms of if somebody let's just say the response time for somebody to see something and then put their brakes on and what that response time is. And then how much that's affected by brake pads being worn down. I'm literally making this up. But let's say that that's what they're going to testify to, because they're an expert. They're the world experts in brakes. Okay. Well, one could still say, if you're the opposite party, one could still say, well, they're just an expert in how brakes work. They're not really a crime scene expert. Okay. Does that make sense? So it's kind of like that languaging. On May 21st, 2024, the defendant provided the Commonwealth with the curriculum vitae of Dr. Marie Russell, an expert witness not previously disclosed. On May 30th, 2024, during the 6th week of trial, Attorney Little provided the following synopsis about Dr. Russell. That's teeny tiny. Zooming in. Oh, wait. Okay. We're going to have to use our eyeballs. She has reviewed the autopsy photos, grand jury testimony of Dr. Squirty Bello, the entirety of the autopsy report, all reports associated with Chloe's prior bite history. So we're back to Chloe. Chloe is back on the radar. Photographs of the items and evidence, and the UC Davis DNA testing results and evidence submission forms. So the UC Davis DNA, that comes from the dog lady whose name I can't remember. I'm sorry. She's great. She's expected to be called with focused testimony related to the right arm injury sustained by Mr. O'Keefe. Dr. Russell will testify that the wounds and injuries on Mr. O'Keefe's right arm are consistent with an animal attack, namely teeth or claw marks, or a combination of both from an animal. She will also testify that these injuries are inconsistent with having been struck by a vehicle. I mean, I would say that you don't even need an expert for this, to be honest. I think I don't think it's necessary. I think that this is over for the Commonwealth and has been. But also, eyeballs, I think, and common sense really are enough. I don't think any jury is going to think that anything the Commonwealth is saying is accurate. Now, really, like, should anyone on that jury know anyone who was ever in a car accident or had anything like that where they were dragged or cut with an accident like that? They're just going to look at that and be like, there's no way. Anyway, namely teeth or claw marks or a combination of both from an animal. She will also testify that these injuries are inconsistent with having been struck by a vehicle, road rash. Again, all of this to me is common sense, but yeah. Or scratches from broken glass or taillight material. Yeah, of course it is. She will base her opinions and conclusions in part, I'm adding this myself, on common sense, but that's not what it says. On having treated hundreds of patients in the ER with injuries sustained from animal attacks, including dogs. No written reports or opinions from Dr. Russell were provided. Well, okay, there's already a cure that I can see for this, which is they turn over the reports or opinions to the Commonwealth, right? Like, in other words, it sounds like the Commonwealth's kind of like, and I know you're supposed to turn shit over, but having said that, I don't have any sympathy for them because, like, we all know the job they've done. Okay, let me see what y'all are saying in chat. So, oops, hold on. Oh, so yes, for lurkers, let's do this one. Oh my God, thank you, DSN. DSN says, I'm an expert at throwing my phone around my office and reporting whether it registers. Thank you for that. You guys, I just love it. I love it. Just, it's like, for me, it's like, oh, it's nostalgia, it's memories. I love it. I love it. We had the best time. And I don't think I did Super Planner Girls commands. Let me do that. Did you actually fall down a cliff, Blackwater? That sounds insane. That's correct, Super Planner Girl. Yes to the pig DNA, but there's various explanations for that. Like the pig DNA at first sounded really bizarre, but bacon apparently can cause that. So if remember, and there was throw up on his shirt, vomit, right? So if he or whoever's, we don't know whose that was because no one's testing it apparently. But if somebody had bacon and threw up, that could cause it. Also, things like dog treats, So, Dog Lady was early on in the trial, Blackwater. Oh, you didn't miss Dog Lady. Okay, yes. So, that's wild. I'm very accident prone. I've had a lot of things, but I don't think I've fallen down a cliff. My mom has, though, when she was a kid. She has a good story about that. Whenever I run out of stories, which I don't know, that's going to be tough. I have a lot of stories, but I can always resort to my mom's and my dad's, my parents' stories because they also have a ton. Okay, so yeah, no written, right. So I was just saying, like, this could maybe just be cured if they just were to turn the shit over, right? From Dr. Russell. Okay, a criminal defendant's constitutional right to call a witness on her behalf is not absolute and may be limited in the judge's discretion in the face of legitimate demands of the adversarial system. Commonwealth v. Branca, 46 Mass. So, okay, again, this is another case law from the, this was the Massachusetts Court of Appeals from 1998. Citations and internal quotations omitted. What? Obviously. The defendant filed the notice of experts 1 day before trial. You already said this at the very beginning. It was your first sentence when I was like, this is weird. Okay. On April 15th, 2024. And for Dr. Russell on May 21st, 2024, with a synopsis of her opinions over a week later on May 30th, 2024, during the 6-week trial. For violations of massacrimp, a judge may, in her discretion, bar these witnesses from testifying. More case law. This sanction may not be imposed without a judge's balancing, why is that possessive? Balancing the Commonwealth's interest in enforcing its procedural rules against the defendant's constitutional right to present evidence on her behalf. Where you see this, well, okay, we should not ever be, it's clear that everything the Commonwealth does in this case, including the court filings, are a disaster. So not that we want to use this as a good example. However, just for future reference, y'all, if we're doing documents, whenever you see ID dot like that in case or in court filings, what that means is it's citing the same, whatever case law citation was there previous. So here, this is a mess, like I said, but the ID thing still, it means the same, which is that this would be citing this same case law here, and they just didn't type it out again. Factors in assessing such a balance include 1, prevention of surprise. I don't know where to begin if I got on that rabbit hole with the surprises in this case. 2, evidence of bad faith. Wait, all we have is evidence of bad faith. I'm confused. 3, prejudice to the Commonwealth. 4, the effectiveness of less severe sanctions. And 5, the materiality of the testimony to the outcome of the case. See, again, this is weird. It shouldn't be written like this. Damn it. Commonwealth v. Durning, and we got some Massachusetts Supreme Court case law, and then another case, Commonwealth v. Chappie, and again, that's the Massachusetts Supreme Court. All right, and then I think this is the last page. Yep. All right. The Commonwealth moves to exclude Dr. Russell's testimony as the Commonwealth is prejudiced by the extremely late notice of Dr. Russell. The Commonwealth has called over 50 witnesses thus far, and a request, that's true, they have, and a request for continuance 7 weeks into trial is impractical. Actually, now I'm trying to remember, they're on witness, let me think, my brain. I believe it's witness 55 is who they're on right now. Yuri's witness 55. This sentence is funny, though, because it says that, like, when I read this and it says, the Commonwealth has called over 50 witnesses thus far, in my mind, it's like, what should follow that is, and still has not proved a goddamn thing, except that it was snowing. But that's not what it says. It says, in a request for continuance 7 weeks into trial is impractical. In addition, jeopardy has attached. Well, that's true. Let me know if you're curious and want to know more about double jeopardy, but that's what that says, and that's actually accurate. The Commonwealth is furthermore prejudiced by the defendant's decision to elicit this testimony, and that's spelled wrong. That should be an E, not an I. Oh my God. He spelled illicit like illicit drugs and not illicit like squeeze from. This testimony and the surprise it has caused. Again, with the word surprise, and he's saying he didn't. Okay. During a final pretrial hearing on February 15th, 2024, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such a claim, I should say. It was not until April 29th, 2024, during opening statements, where, contrary to the court's prior ruling, that third-party culprit evidence was not admissible or appropriate for opening statements, Attorney Yannetti unfairly prejudiced the Commonwealth by... okay, I have problems with this. Why? Okay, well, something's wrong here, and here's why. Okay, so let's start with this. Here's the statement. Karen B was framed. Her car never struck John O'Keefe. She did not cause his death, and that means that somebody else did. Yes, that is something that would qualify as something like third-party culprit evidence. I'm going to start with this. Well, I knew nothing of this case until the trial started. It's clear that that was their strategy all along, first of all. Second of all, whether that was their strategy or wasn't their strategy, it's my opinion that it was. If indeed the court ruled that third-party culprit evidence was not admissible or appropriate for opening statements, guess what would have happened? Judge Bev would have shut that shit down. And even if that didn't happen, guess what? Freaking Lally could have objected and it would have been sustained if this was accurate. So something's wrong here. Either Lally's making shit up, or I guess that's really the only option, actually. And here it is 6 weeks later. Like, y'all, you guys know how this works, right? It's like, if it was really an issue, it would, Judge Bev, even though maybe she shouldn't be intervening, she probably would have intervened because that's what she does. But nonetheless, it is up to the other party to make an objection for the judge to rule upon. And if you don't make the objection, too bad, so sad. You snooze, you lose. So, all right. And then surprisingly proceeded, again with the word surprise, that's the third time so far in this document. Maybe fourth time? It's at least the third time, and it's only 4 pages long. We're not even finished with it. Proceeded to claim that the defendant's injuries were consistent with a dog attack. In light of this, on May 15th, 2024, the Commonwealth called Terry Kuhn, that's the dog lady, a forensic scientist, to testify that there was no canine DNA present on samples provided to her veterinary forensic laboratory. Now there's a footnote, but there wasn't a footnote for the case law. Ms. Kuhn did not render an opinion about the cause or appearance of John O'Keefe's injuries, nor offered any testimony about whether John O'Keefe's injuries were consistent or inconsistent with an animal attack. Well, of course she didn't. That's not her job. Her job is just to test the DNA. Commonwealth is unduly prejudiced, fucking hell, by the defense intentional delays in providing appropriate discovery and notice to the Commonwealth. And again, with another fucking messed up grammar situation. Oh my God, you guys. C. Reynolds, 429 Mass. Again, this is more Massachusetts Supreme Court case law. In parentheses, with no quotations? You've got to be fucking kidding me. Okay. All right. If you're going to cite case law and you're going to include anything from the ruling, right? The holding, you have to have quotes. You have to put quotations. If you're going to paraphrase it, you have to say so. You have to say so. This is insanity. I feel like I'm in the Twilight Zone, but of course, but like what? And look at this. Look at this. Look at this. Oh my God. Bad faith when failure to provide discovery is deliberate and willfully motivated by desire to obtain. Wait, what? See, you can tell Lally wrote this because it makes no sense. I'm going to read this again. I'm going to read it verbatim. I'm not going to correct it, although my brain wants to. This is what it says verbatim. Bad faith when failure to provide discovery is deliberate and willfully motivated by desire to obtain a tactical advantage that would minimize the effectiveness and cross-examination. This makes no sense. I can't even handle this all. It's like a run-on sentence, but yeah, it's an incomplete sentence. The effectiveness of cross-examination and the ability to induce? Is he supposed to mean, like, you guys, adduce rebuttal evidence, internal citation omitted, and that's the end of it. There's not even like a closing thing. And here's the footnote, the lone footnote in the document. Due to personal reasons of Ms. Kuhn. See, now there, if they wanted to include that it was her personal reasons, that should have been possessive. However, that's not necessary. They could have just said due to personal reasons. But my point is this makes no sense as it is. It's not necessary, but also it's not correct. The grammar is not correct. An out-of-state witness, she was, this is a mess. She was unavailable. This could just say, due to personal reasons, Miss Kuhn was unavailable after May 16th. You can tell Lally wrote this. You can tell because his questions, this is such a fucking disaster. It's not possible that anyone else could have been responsible for this. Like, this reads just like his questioning, with the exception that it doesn't include what, if any. It has other Lollyisms, though. So I think that what we're seeing is, like, he's got his own set of Lollyisms for writing and maybe another set for speaking. But this hurts my brain. Let's see what you guys are saying. Are you guys like, what the fuck's happening? Oh, random girl said she just stuck a cake in the oven. Is it their birthday? That sounds festive. Happy to see you. Super Planet Girl saying, hang tight. Didn't they say on Friday that video was just to show to Trooper B like last week? I'm not sure what you're referring to. Was this with him on the stand, or was this with a different witness? Yeah, Mrs. Lally obviously didn't proofread. Yeah. Oh, thank you. Yes, EDR is the vehicle black box. Okay, that makes sense. Yes, pulling teeth indeed. So that's a good question. What I can say to that end is that this is a renewed motion. So that means that this was already a motion that had been filed and it was already ruled on. It was denied. Like, in other words, like, this motion had already been filed and it had already been denied. So they're renewing it. All I could think about, like, what this could be is because the Commonwealth, believe it or not, is getting ready to arrest their case in chief. They would have to have, like, if they wanted to renew this motion, which they did do, it would have to, like, where you're going to have defense calling in experts. It would have to be done before the defense starts its case in chief in order to stop them from testifying. That would be one thing, right? Like, they needed to have this filed before it was too late, essentially. I don't think it matters. I've said it before and I'll say it again. On the day with the solo cups, this trial was fucking over, in my opinion. And I mean, it was already questionable to start with before that. So, yeah, I have not heard that ever, adduce, as a legal term. I've not heard that or read it in a court document. So I agree. DSN says, I think it means Lally is a douche. Yeah, absolutely. That's what it is. To cite as evidence. Okay. Yeah, I mean, let me go back to that, where that was. I'm surprised I haven't seen that before. Okay, let's see. Well, right. And also, it was a part of this messed up piece of shit show, whatever, here. Like, that doesn't help anything. To the advantage that would minimize the effectiveness across the. Yeah, I feel like there's other words that normally people would use here. I've just not seen that word. But thank you for letting us know, Super Planner Girl, if indeed that is a legal term. Candace says, I'm wandering around the grocery store saying induce, produce. Lovely, lovely. Yeah, it's a mess. It's a mess. It's an absolute mess. So y'all are funny. Okay, so I don't even know what time. I'm so confused. The whole thing is so funny with, like, the scheduling and trying to do with the StreamYard and the YouTube. I don't know. I'm assuming that the other stream is, so, like, with redirecting it, like, it should, like, the other stream has to already be like it has to be time for the other stream. So it's a funny thing timing wise. I would assume that was supposed to already start. So I tried to make sure that would overlap because it has to. Oh, here's some more comments. Oh, okay. Okay. That's fucking funny. I know, right? So Super Planning Girl says the Commonwealth is not going to bring an Emmy or sell evidence. There's so much. They haven't done any telemetry on Karen's car. They haven't done anything in terms of actually getting to, like, and it's funny because we have not heard any discussion, because like sometimes in these other trials that we watch, we hear as them asking like how much longer for the case in chief, right? And they say something like, oh, 1 day or a week or 5 years or whatever, or how many more witnesses. And we've not heard any discussion about that. So it's really funny that they've not talked about it, like at least not on the record, as far as like how many witnesses they intend to call. Oh, okay. Yeah. Thank you, Super Planner Girl. But I will say I don't understand how they could not bring in a medical examiner, or at least corner armpits, or someone with the telemetry, or someone with the cell phone data. There's so much stuff that has to still be talked about. But having said that, at this point, literally nothing would surprise me when it comes to this case. So I don't know. And as I say that, I'm still going to be surprised. It's like both at the same time, Twilight Zone. So that's where we live here now. So all with that, I think it should be time for the other stream, in which case it should redirect you guys. So if it doesn't, just click on it. But what I'm going to do is, hold on. Yeah, no, I'll end this stream and then it should redirect you into the other stream with the recap. And if it doesn't, just, y'all can figure it out, because you guys are smart. I think it's so funny, like in other times where there's other channels and it's like people don't get redirected, like, I'm lost, I don't know what to do. And it's like, you don't know how to just click on the stream, but it's okay. It's all good. You guys are smarter than the average bunch, I think, is part of it. So, all right. So I'm going to end this stream and then we're going to pop on over. And through the magic of technology, should it not fail us, I'll see you guys in just a second.